Hello everyone, welcome to our exam B. Today in this video, I'll be continuing ahead with our series with respect to what to study from the various laws, the acts with respect to the various competitive law exams. But before we move ahead with our today's discussion, do remember to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. Today in this video, I'll be discussing about what to study from the Indian Evidence Act. But before we go ahead with our discussion, let me remind you कि अगर आप में से किसी का भी मिस हो गया है कोई भी वीडियो देखना इस सीरीज का व्हाट टू स्टडी फ्रॉम द वेरियस लॉ सब्जेक्ट्स, देन यू कैन गो टू द डिस्क्रिप्शन ऑफ दिस पर्टिकुलर वीडियो वेयरइन यू विल गेट द लिंक फॉर द प्रीवियस वीडियोस. नाउ मूविंग अहेड विद आवर डिस्कशन ऑफ द इंडियन एविडेंस एक्ट. सो व्हाट इज इंडियन एविडेंस एक्ट एक्चुअली? इफ वी टॉक अबाउट दैट, सो इट इज वन ऑफ द लॉज व्हिच एक्चुअली प्रोवाइड्स हेल्प टू द कोर्ट्स so that they can discover the truth, and based on that they can decide the case depending upon all the facts and evidences which are being produced. Before I go ahead with our discussion of the important sections of the Indian Evidence Act, let me tell you कि Indian Evidence Act का almost सारा sections ही बहुत important है. But इस particular video में मैंने वो कौन से sections है जो कि बहुत ही ज्यादा important है. Means when you read Indian Evidence Act, you can make out that most of the sections are important. But as mentioning that only over here कि इस particular video में मैंने उन सारे important sections में से कुछ बहुत ही ज्यादा important, the most important sections I have taken up and which I'll be telling you in this particular video. You can see that section 3, which is the interpretation clause or the definition section, that is important. Then section 4, which is talking about may presume, shall presume and conclusive proof, इससे related aspects provisions covered है section 4 में, तो वो आपको study करना है. Next is the various provisions related to the relevancy of facts. So in this basically section 5 to 16 you have to study thoroughly. यहाँ पे section 5 आप देख सकते हो, that is talking about evidence that may be given of facts in issue and relevant facts, relevancy of facts which are forming part of same transaction, when facts not otherwise relevant become relevant, then facts showing existence of state of mind or of body or of bodily feeling, existence of course of business when relevant. Now moving ahead, you can see section 17 to 21 जिसमें की provisions with respect to admissions and all covered है. तो section 17 जो है admission को define करता है, वो important है आपका. Then further आप देख सकते हो admissions by the persons whose possession must be proof against the party to the suit, proof of admission against person making them and by or on their behalf. Then admission in civil cases when they are relevant, confession by police officer not to be proved, how much of information which is received from the accused they may be proved, admission not conclusive proof but may stop. So basically over here you can see section 17 to 27 and then section 31, that is important. Section 33 फिर आपका important है क्योंकि वो provision lay down करता है relevancy of certain evidence for proving in subsequent proceeding the truth of facts. Section 40 is related to previous judgments relevant to bar a second suit or trial. And then आपका section 45 and 45A important है, that is talking about opinions of the experts and of examiners of electronic evidence. So these provisions are all important. Then आप देख सकते हो कि section 47 or 47A, that is related to opinions as to handwriting when that is relevant or to digital signature when that is important. So section 47, 47A में से related provisions covered है. Section 52, 53 and 54 is important because they are basically talking about the provisions with respect to in civil cases character to prove conduct imputed irrelevant, in criminal cases previous good character that is relevant, previous bad character is not relevant except in reply. So these are important provisions. Section 56 जो की बात करता है fact judicially noticeable they are not required to be proved, provisions with respect to that. Then 59 and 60 is important because यहाँ पे provisions है proof of facts by oral evidence and oral evidence must be direct. And then section 62 and 63 very important because primary evidence, secondary evidence, the provisions related to that, what are these, all those aspects have been covered. So ये बहुत important है. Section 67, 67A, that is proof of signature and handwriting of person alleged to have signed or written document produced, proof as to electronic signature. So these two are important. Then section 74 to 76, public document क्या है, provisions उससे related, private document, then certified copies of public documents. Section 79 and 80 important क्योंकि that is talking about the presumption as to the genuineness of the certified copies and the documents produced as record of evidence. तो ये दोनों से related presumptions के जो भी provisions important है. Section 85A to 85C, that is talking about again presumption as to electronic agreements, electronic records and electronic signatures, then electronic signature certificates. So presumptions related to those. Then आपका 85C के बाद 88A to 90 20A, that is presumption as to electronic messages, due execution of documents not produced, documents 30-year-old, and electronic records 5 years old. So what are the various presumptions, the various provisions related to these? They have been covered under 88A to 90A. Burden of proof is under 101, वो important है, and on whom the burden of proof actually lies. So that is covered under section 102. So 101 and 102 related to burden of proof. Now moving ahead, you can see section 105, which is talking about burden of proving that the case of abuse comes within exceptions. That is important. Then 105 के बाद आपका 112 important है. That is related to birth during marriage, conclusive proof of legitimacy. उससे related provisions है यहाँ. Then 113A and 13B, that is presumption as to abatement of suicide by a married woman and as to dowry debt. So these two are again very important. Then section 115 to 117, that is talking about estoppel. So what is estoppel and the related provisions they have been contained, that is important. Then section 126, professional communication से related यहाँ पे provisions है. 129, that is containing provisions with respect to confidential communications with legal advisors. Section 133, a compliance, and 134 is talking about number of witnesses. So all these are very important over here. Now next moving on to the other important provisions, you can see section 135 important है, जो की बात करता है order of production and examination of witnesses. What has to be the order and how that has to be produced and how the examination of witnesses will be taking place. Related aspects have been covered. Section 137 and 138 important है, because यहाँ पे examination in chief and order of examination से related provision है. 140 to 143, that is talking about witnesses to character, leading questions, when they must not be asked, when they must be asked. So again, these are important. Impeaching credit of witnesses, refreshing memory, and lastly section 167, that is no new trial for improper admission or rejection of evidence. So all these are very, very important sections. Okay. With this, we come to an end of our today's discussion with respect to Indian Evidence Act. But do remember to subscribe to the channel and press on the bell icon so that you can stay tuned and stay updated. If you have any questions, queries, doubt, you want to clarify, you can approach us through the email ID which is displayed on the screen, or you can even give us a call on the number. इसके अलावा आप हमारी वेबसाइट को जरूर विजिट करें, जहाँ पे कि आपको डिटेल इन्फॉर्मेशन मिल जाएगा with respect to the various competitive law exams. So stay tuned and stay updated.